Hello everyone, my name is Salvatore Di Costanzo and I'm an elder law attorney and estate planning attorney in Rye and Yorktown Heights. And it's good to be able to continue these weekly chats on various topics. Just want to once again say thank you to all of our essential workers out there. Thank you for all that you've been doing for us in the time of this pandemic, and we give you all of our gratitude. So today what we're going to be talking about is something that comes up very often, and it's the probate process. We often work with people and get questions from people asking just exactly what this probate process is. And it's confusing at times, especially if you've never been through the probate process. And you know, when we start talking about drafting estate planning documents and the different types of documents that you need, there are a lot of misconceptions. So what I'd like to do today is just educate you just a little bit about the probate process, what it means, what it looks like, and then also talk to you about some of the reasons why you might want to avoid probate. Avoiding probate could really, in today's day and age, avoiding probate is sometimes a necessity. And so I'll talk to you about when you really need to consider to avoid probate. So what is probate? That's the fundamental question. Probate is the process of proving the validity of your will after you die, right? So when you die, we take your will and we go to the surrogates court. In Westchester County, it's the Westchester County Surrogates Court. Each county has their own surrogates court. And you present the will to the court, and you fill out a bunch of papers, and you go through a bunch of formalities. And in a fairly basic estate, the judge looks at the will and makes sure all the formalities of the will execution were followed. And when he's comfortable that the will is valid and the formalities of a will execution have been followed, he officially appoints the executor. So this is a really important concept. People come in all the time and they say, well, I'm the executor of my mother's estate. Well, what does that mean? Just because your mother drafted a will and put you in her will as the executrix doesn't mean that you've got the power to handle your mother's affairs. It's only once the court appoints you as the executrix that you can then go out there and sell her house or move the financial assets to the beneficiaries or set up a trust, whatever it is that her will says. So it's very important to understand that just being named in somebody's last will and testament is what we call a nominated executor. You've been nominated, but you still have to go through the process of proving the validity of the will and getting appointed by the court. So a lot of people often say, but Sal, I don't understand. I have a will. Why do I have to go through probate? That's exactly why you have to go through probate. When you have a last will and testament, the last will and testament has to be proven to the court. Sometimes people think that by drafting a last will and testament, you don't have to go through probate. That's wrong. That's a misconception. We'll talk about how to avoid probate in a little bit. But a last will and testament is subject to the probate process. Now, what does the probate process look like? Well, it could be very simple. It could be complex. The probate process requires certain papers to be completed. Some of those papers that need to be completed, signed, are papers that need to be given to your next of kin. So we might fill out a petition, right? The petition says that Mr. Jones died on such and such date. Here's his death certificate. Here's his last will and testament. And New York state law requires that his next of kin sign off on the probate proceeding. And this is a very important point. It's very interesting. In a basic estate, let's say dad dies, survived by a wife and kids. Well, everything is very simple. It's fairly straightforward. Let's say all the assets are being left to mom, or maybe they're even being left to the kids. Those people need to sign a piece of paper. They sign it. It gets presented to the court. No problem. What's disturbing to some, though, is when you have a last will and testament that leaves, let's say I leave my assets to a charity, right, or to my best friend. New York state law requires, as part of the probate process, that my heirs be sent a copy of my last will and testament, and that they sign something called a waiver and consent. That they're waiving any rights that they have to be appointed, and in essence to contest my will, and they consent to the appointment of whoever the executor is. So we have clients that often leave their assets to a certain family member in their last will and testament. And then I tell them, listen, but who are the next of kin? Who are the heirs at law? And it could be that you're leaving your assets to, like I said, a best friend, but my children are my next of kin. My children have to sign those waivers and consents. And depending on the fact pattern and the family dynamics, that could be a real problem, right? You may not get along with your kids. The kids may not want to sign. And people don't understand why the kids need to sign papers when I've provided in my last will and testament that my best friend gets everything. And the reason being is that New York state law says, in order to prove that this will is valid and to make sure that there was no undue influence, that there was no coercion or duress, that my best friend did not force me to put him in my will as the sole beneficiary. We want to hear, as the court, we want to hear from all the people that would have inherited your assets if there was no will. So in New York State, if you die without a will, there's a statute that talks about how the assets pass to your next of kin. If you're survived by a spouse, it goes to your spouse. If you're survived by a spouse and children, it gets split up between your spouse and children. If you're survived by only children, it's your children that inherit. So the court wants to know from those people, because they have an interest, right? If something went wrong, those are likely going to be the people that are going to say something, right? If something went wrong, if my best friend was real close to me and really, somebody had some sort of indicia that he might have influenced me, those kids are going to say, hey, wait a minute. My dad left everything to his best friend? No, there's something wrong over here. We should have been the ones that inherited that. And then they can come in, and that's when you have a will contest. Because what they'll do is they won't sign those papers, and they'll come in and they'll contest the will. Right? So that's part of the probate process. So you could see how the probate process can get somewhat complicated if we've got these varying fact patterns. Ultimately, the papers are presented to the court, they're reviewed by the court, and if there's no problem, undue influence, coercion, if the kids sign, if everything goes well, the court then officially appoints the executor. And that could take a few months, right? It doesn't happen overnight, so it could take some time. The probate process can become more and more complicated based on the fact pattern. So for instance, let's say there's a disabled child in your family. Well, if that's the case, the court is going to appoint what we call a guardian ad litem to look after that disabled child's interest, even if they're not a beneficiary of your will. They're going to come in and they're going to look over that child's interest to make sure that there was no undue influence, coercion, duress, if your assets are being directed somewhere else. Same thing with a minor beneficiary. These are all things that can complicate the probate process. Now, people come to us and they say, well, Sal, what needs to be probated? When do I need to probate? Just because I have a last will and testament doesn't mean that I have to probate, and that's true. Just because you have a last will and testament does not necessarily mean that you need to probate. When do you have to probate? Well, when you have probate assets. What are probate assets? Probate assets are assets that are in your name individually when you die, that do not have a joint owner or a beneficiary designation, or any other type of post-mortem designation like transfer on death or in trust for. So, your house. If you're married, you might own your house as joint tenants with your spouse. So when you die, the house automatically passes to the surviving joint tenant. That doesn't need to go through probate. It's called passing by operation of law. We've avoided the probate process. You have a bank account. You've got, it's transfer on death to your children. When you die, those assets transfer automatically to your children. It does not need to go through probate. Life insurance has beneficiary designations. IRAs have beneficiary designations. You do not need to go through probate. So one of the most important things, and I talked about this last week in a separate video, is to make sure that your beneficiary designations are up to date, that they're accurate, so that way you don't end up with no beneficiary, which means that your estate becomes the beneficiary, which results in a probate of your will. So that's very, very important. So only certain assets go through probate. Those are the assets that are in your name, solely in your name, with no designation to pass to somebody else at death. Those are your probate assets. And often people end up going through probate by accident because they didn't do the right planning. They didn't put their affairs in order. They didn't make sure that their I's were dotted and their T's were crossed. And so mom or dad passes and you know, we've got assets, right, that need to be probated. What happens in the case of that house that I just talked about? When the first person dies, no, you don't need probate, but then the second person dies. There's no beneficiary on the deed. You know, there's no you know, transfer on death, so we have to probate, which is good reason to do things like the Medicaid trust and other types of trust that we'll talk about in a moment. So not everything needs to be probated. Only certain assets need to be probated. So we've talked about probate and what the process looks like. We talked about the assets that need to be probated. We talked about some of the things that go on during the probate process, like a will contest from your beneficiaries or the appointment of a guardian ad litem over disabled or minor beneficiaries. Let's talk about why we might want to avoid all of this, right? Because all of these things that go on in the probate process could take a lot of time. It could cost significant legal fees, and it could stall the transfer of your assets to the next generation. You know, let's, for instance, talk about the house again. If we have to wait to probate your will, and you've got maybe a willing buyer, you know, your kids have a willing buyer, they want to sell the house, and that buyer's got a couple of different opportunities, and they're not in a position to wait. Your kids might lose the deal. They might lose the opportunity to sell your house in a timely fashion because they got to go through probate. And we've got to wait for that process to unfold, and we've got to get letters issued by the court. So it's sometimes good to avoid probate. Now, how do you avoid probate? By the way, I just used the word letters. Let me go back for a moment. Once the executor is appointed, the court signs a decree, and they issue these certificates called letters testamentary. So anytime you hear the words letters testamentary, you might see this like if somebody passes and there's I have a case right now where somebody passed, they didn't have a beneficiary designation on their life insurance policy, so the insurance company sent the client, the surviving spouse, a letter saying, send us copies of the letters testamentary and then we'll work with you to cut you a check for the death benefit. That means that they've got to go through probate. We've got to go through probate, and we've got to get letters testamentary. That's the official appointment by the court. If there's a trust being set up under the terms of a will, letters of trusteeship. So it's a little bit different, but it's sort of the same thing. So when do you want to avoid probate? So there's a lot of reasons to avoid probate. Let's talk about them. I told you that as part of the probate process, regardless of what your will says, your next of kin have to sign a piece of paper. So that way that probate process can go through. What if your next of kin are distant relatives? What if they're nieces and nephews that Perhaps they don't even live close to you, or maybe you haven't even seen them in many years. Well, under the statute, they're required to sign that piece of paper that I just talked about. So if you're a single person with next of kin that is somewhat scattered, or maybe you don't have a relationship with your next of kin, you want to consider avoiding probate. And how do we do that? By drafting a revocable trust. So the answer to avoiding probate is by drafting a trust. So instead of a will, we might want to set up a revocable living trust, right? Some people call it living trust. And put your assets, your house, let's say, into that trust. So that way when you die, you do not need to probate. Trusts do not need to go through probate. So if you fall into the fact pattern of somebody with distant relatives, and you know Sal said that upon your death, all these people are going to have to be contacted and have to sign a piece of paper, you're a candidate for trying to avoid probate. And to avoid probate, we need to talk about a revocable trust. When else do we want to avoid probate? What if you've got property outside of New York State? What if you have a house in Florida or the Carolinas? We first have to probate your will in New York, and then we've got to take your will to that other state and do it all over again. It's called an ancillary administration or an ancillary probate. That's double the time, maybe double the legal fees, and a lot of anxiety and stress. It's almost an absolute that if you've got property outside of New York State, you should be considering a revocable trust. Because what we can do is we can draft the revocable trust, we can take your property and put it into that trust, and then you avoid probate in New York and the other state. So for the time and expense that it takes to do it today, you're going to save a lot of time and expense later on for your kids or for wherever your heirs are. So what if you have minor children as beneficiaries of your estate? This is a big deal for younger families. You should be thinking about setting up trust for your kids. You don't want to leave assets outright to your kids. So if we set up those trusts under the terms of your last will and testament, the court is going to be involved with those trusts for a long period of time, right? You have a will, it goes through probate. The will says, set up a trust for my kids until they're a certain age, or maybe for their lifetime. The court has oversight over those trusts. So now you've got to be involved with court intervention, filing accountings, that could turn into judicial accountings, and dealing with a lot of the red tape of the courts for a long period of time. We don't want that to happen. Younger families, especially in today's day and age, you want to make sure that you provide for your children by using trust. There are a lot of reasons why trust, even after the children are 18, in other words, once they reach the age of majority, there's still very good reason to use trust. Asset protection. What if your kids get divorced? If they get divorced, we want to be able to protect the assets from that spouse. You know, maybe you have a child that's a spendthrift. These are all good reasons to talk about continuing trust for your children. If we're going to do that, we really want to consider a revocable trust as your primary planning technique instead of a last will and testament. Same thing goes for disabled beneficiaries. If you have a disabled child, we want to set up a special needs trust for that child, for the child's lifetime. We want to do that through a revocable trust. So these are very good reasons to want to avoid probate, to reduce the time that it takes to get the assets to pass to the next generation, and to also reduce the cost involved with the probate process, and to take away a lot of the anxiety that your family members might have to deal with by going through a probate. Granted, some probates are very simple. A husband, a wife with kids, a few assets. If everybody does what they're supposed to do, and we sign the papers and we submit it to the court, it could happen relatively quickly. But in a lot of cases, probate can take a long time, and there could be a lot of obstacles to overcome in the probate process. So I hope that helps you understand what the probate process is, and hopefully clarify some of the misconceptions that are out there regarding the probate process. There are a lot more questions that people usually have that you're free to ask me. You can email me. But those are some of the major issues that we see on a regular basis with probate. And I'm happy to help you, whether it's to plan to avoid probate, or if unfortunately you have somebody in your family that's passed on and you need to probate an estate. We're happy to help to get you through these tough times. And if you would call us, our phone number is 914-925-1010 or 914-245-2440. My website is plantodayfortomorrow.com. My email address is smd@mfd-law.com. And if you like these recordings, I would really like it if you would share them with your friends and your family. They're very valuable. They'll be on my website, and you can see all of the prior recordings as well. And we're getting a lot of good feedback that people are learning things that are very important to them. And hopefully I'm answering questions that may be lingering and create the impetus for you to give us a call and do your planning. With that being said, have a nice day, stay safe, and stay healthy.